Mr. Eli Bugatti, it's number 286540, today for a novo hearing. I take judicial notice of the court's file and its contents. I note that there is a April 16th, 2025 order enforcing support and medical support obligations signed by Judge Nelson. And then are you ready to proceed today on the novo hearing?
Yes, Your Honor.
Ready to proceed today?
Yes, Your Honor.
All right, thank you. Then, and I do note that the respondent, Michelle, we're going to have the name called and then I'll announce whether there's been any response. We've already checked once, there was no response, but we'll check again. Mr. Bugatti, this is your request for a novo. I've reviewed your pleading, but go ahead and you would you like to present your argument as to what the rule is today?
Yes, Your Honor.
So, make sure the microphone is turned on over there. Just get when you talk over the same.
Okay. So, if it's okay, Your Honor, I'd like to submit my memorandum of law for my due process paperwork as evidence.
Your Honor, we have not had a chance to review that.
If you have a memorandum, you have a copy to provide to the AG's office to review?
I only have one copy, and they are able to have it, but it was filed and served February 14th of 2025 to the district clerk.
Your Honor, that may have been filed, but it was not served on our office.
And that's true, it does not show, there's an e-file service list and the Attorney General is not included as service. So do you want to provide?
I'd also like to submit another form into evidence. I do have 4 copies.
I'm sorry, what was that?
If it's okay, I'd like to submit another form into evidence. It's from the OAG's office. It states that, if it's okay, I'd like to submit it into evidence, but it states that, please be aware that our attorneys represent the state of Texas while they provide you with child support services. They are unable to represent you or any individual.
I would like to look at it first, Your Honor. If that's all it says, then I have no objection.
I think I gave you 2 copies.
Before you continue on and requesting, could you tell me, is the form of relief that you're requesting today, is there anything other than what you've identified in your pleading that you're requesting for relief?
So the reason why I'm requesting relief, my original child support order was granted while I was active duty back in 2016. I became 100% disabled veteran in 2019. My child support order was $386. I actually went to the child support office and provided them with my 100% disabled permanent total form, and the OAG more than doubled my child support. They didn't go through the proper process, which is the apportionment process. And I do have the form according to
I just want to be clear that you understand that the novo hearing is a request for me to review the order that Judge Nelson has entered. We're not relitigating something from 2019. You understand that this is based upon what happened most recently in court and the April 16th order, right?
yes.
You understand that?
Yeah.
Okay, so please limit your discussion and any evidence and any argument as to issues that relate to that order and the findings that were made in that case,
Okay.
or proceeding, I'm sorry. Go ahead.
So I'm requesting relief.
And just to be clear, because my understanding of the order is it's an enforcement order that identified child support arrears. So it confirmed arrears, granted the judgment, released a portion of the judgments. A medical support judgment, and that was it. So as far as setting amounts of support, I don't see that that was ordered. That's something from that's previously been ordered. So you're limited in a de novo, you're limited to taking up the issues that are in that order. You don't get to go back and relitigate things that happened 3 years ago, 2 years ago. You're limited to what was taken up and ordered in the April 16th order. You understand?
Okay.
So if you can address those items, I'd appreciate it.
So I'd like to tell the court.
And the reason why I'm telling you that is because there are different ways to do what I think you're trying to suggest. A de novo is not a way to modify an order. If you believe that there's been a material or substantial change, there's a different process. But a de novo is for me to take up and consider whether things were done properly as to this issue, okay, as to the enforcement. Or at least this de novo. Does that make sense, sir? Okay, then go ahead and proceed.
So my previous hearing, they stated that I was not paying child support, which is incorrect. I do have a VA apportionment ruling, and I am paying my child support. Unfortunately, there is no financial means available to me to pay the OAG ordered child support. I don't have the income for it. I cannot afford it. What I can afford, however, is the $140 that's been ruled on by the Secretary of the VA through the apportionment claims and the VA. And I do have my apportionment ruling here, if I can submit that into evidence. That ruling was based on my child support order, the arrears. So when that took place, you know, the Secretary of the VA, they looked at my current situation, my arrears, and what I was ordered to pay. And based on my disability status, they stated all I can afford is $140 a month. And I'm not here to argue that the state cannot calculate my disability. However, that has already been done through the VA. And I don't have any more money to pay. You know, I just financially cannot do it.
Okay, and response from the AG?
Your Honor, I would say it's my understanding that the VA apportionments, which we have nothing to do with those, I would start off with that. They only take a percentage based on the benefits that the veteran is receiving at the time, and it's most often it's not the total amount that's owed for child support. I mean, if you would like to file for a modification, we can surely take a look at it.
And that's, sir, based on what you've told me, it sounds like you're asking your child support to be recalculated. The issue that was decided at the last proceeding was an enforcement. There was not a modification done. It was not taken up to whether to modify your support or not. The only issue that was decided was an enforcement and to establish how much arrears there was and to set in place repayment of those arrears. And when you de novo that, then that's all I can take up is, okay, was the amount of arrears incorrect? Or is the repayment not legally correct? I can't determine determine, it's not before me for me to decide whether your child support amount should be $1 or $1,000. That's not before me today. That's a separate proceeding that you have to file for different relief. De novo merely allows me to relook at what was before the AG court, before Judge Nelson in that proceeding that the order was rendered on April 16th.
So Your Honor, I'm not asking to have my child support modified. I'm asking to have it closed. I only have my veteran disability to live on. That's the only income I have. So even with a modification, there's no way I can pay more than what is already being apportioned from my VA disability, which is $140.
Do you have any other information that you want to provide me as to the issues that were ruled upon in the proceeding where Judge Nelson made the order on April 16th, 2025?
I believe when he signed that commitment order, that hearing was an appeal to my VA apportionment ruling, which according to the form that Ms. Griffin did receive, and she's not here today to testify, there's a form on there that stated there's only one way to appeal this apportionment ruling. She has 60 days to file the claim with the Board of Veterans Appeal, which she did not.
And sir, I don't have jurisdiction over any veteran appeals issues. That's a completely separate venue and separate jurisdiction. I'm strictly here as to the case that's before me, but I don't have any authority over the veterans of the VA.
So what I would like to ask for, Your Honor, is because Ms. Griffin is not here to testify, to receive more time. Hopefully she can show up, or for me to look for a lawyer that might be better suited to represent me.
Any objections?
Your Honor, I would object. I think we all know that this is not the appropriate forum for what he needs and what he is asking for.
Mr. Kuyati, if you can give me some basis for your request for relief today. Again, it seems like you keep going back to wanting to change the amount that's being paid. And as I see it, that's not before the court. That wasn't before the court when Judge Nelson made his ruling. And because this is a de novo of that proceeding, it's certainly not before me.
So what I like to say is I'm not asking to change my child support order. I'm here to state that I cannot pay what is being asked of me.
And I understand what you're saying, and that, of course, much like would be a modification, just different request for relief, requires a separate proceeding for that. You have to plead differently for that. I can't be your attorney and advocate for you. All I can tell you is what's before me isn't available, or what you're asking me to be able to do today is not available to me as a form of relief based upon what you have filed and what occurred that resulted in the April 16th, 2025 ruling by Judge Nelson. There's all kinds of ways to make changes, to reduce, to terminate, increase. There's all kinds of ways to do that. This is not the way to do that. I will tell you that.
Okay. So what I would like to add is last year I did receive a request to close my case from the Office of Attorney General's the Office of Attorney General. However, a few months later, that's when they started the enforcement process. So the Office of Attorney General has sent me a request to close my form, and it was dated, please sign and return this form within 30 days. I signed and returned it the same day.
And again, And I don't see how that's relevant as to the issue for today. And I don't see that that's been pled, but I certainly don't see that that's relevant for me today.
The reason why I believe that's relevant is because if the Attorney General did go ahead and close my case, as they said they would, I would have never had an enforcement order. I would have never went to jail. So, Your Honor, I do believe it is connected and it is relevant.
Any response?
Your Honor, while a party can request to close a case, if both the parties involved don't request that, we cannot close it.
And I understand that, sir, and that's not before me today. I can appreciate your concerns. The only thing is, I'm a judge, I'm limited to making rulings based upon issues that are properly before me, and that's why you keep probably feeling me trying to channel us back into what's before me, and that probably sounds kind of formal. So what I'm really trying to say is I can only make rulings as to things that are properly filed and properly before me. And a de novo doesn't, at least a de novo as to the proceeding that Judge Nelson ruled on that resulted in the April 16th, 2025 order, there's no way that I can address the items that you've requested me to do today. And my suggestion would be for you to speak to an attorney and get counsel to find out the proper way to do that, so that you might be able to seek the relief that you are requesting. Would you have anything else as to the request before me today?
Well, I have some documents I'd like to submit as evidence to the court.
Well, identify what they are, because the opposing side always has the opportunity to be given notice of those reviews.
So I have my apportionment ruling, which states I am paying child support. I am making a monthly payment on my child support case. It's going directly from the VA to Ms. Michelle Griffin. It comes out automatically. So there is support being paid. You know,
I don't doubt that.
Your Honor, I would like to view it, and I don't think we're gonna have an objection to that being admitted.
I would point out again, sir, whether the issue before Judge Nelson on that was not whether the support was being made, or calculating how much this is owed in the past, and determining the set amount of arrears and how that should be paid moving forward. As I reviewed the file, and you'll correct me if I'm wrong, either side, but there's a previous order of support from several years ago up here. I don't have the date right in front of me. If I scan through the file, I'll find it again. But as I looked through it earlier, there's a previous order of support. Enforcement, of course, relies upon that. But at the time of the enforcement, there was no modification, there was no change in support order. So that's not what I'm here for today.
Your Honor, we don't have any objection to this. We are aware of the apportionment, and I do believe that we have been applying a credit to this for the apportionment, but I will double check on that motion.
All right. So, I mean, as to those exhibits, if you want to bring them up and there's movements exhibit one, and I'll accept them to be admitted. And, sir, the earlier document that you had asked, I think it was about a 40-page document.
yes.
Did Did y'all get a chance to review that? Did you have any objections to that?
Your Honor, I briefly reviewed it. Aside from this not being the proper venue for it, I don't have any objections to it.
It's filed in the court's file. I had seen it.
Okay.
So you don't need to, I'm not going to ask for you to ask that. I will just take judicial notice of it. It's in the file. I had seen it before, but when I reviewed the file. So I was aware that you had filed that in the earlier proceeding.
So is it okay if I turn in the,
Sure, just bring it up and bring it up to me.
to the clerk or to you?
Now, you may make your one excuse different than I do. This say movements exhibit 2 or 1?
The first page is number 1, and then,
Because I'm gonna staple this all together and call it movements 1, okay? And your memorandum, I'm gonna get back to you because it's
already so.
Now, I already took judicial notice of it. It's in the file. There's the file. I'll put my file. Yeah, I'm gonna call this 1. I'm gonna step to. All right, and sir, do you have anything else?
I'd just like to reiterate that I am paying my child support. I know the OAG's office stated they're giving me credit for that payment. However, they're not. The only way that they stated they would give me credit for that payment is if I choose to modify my child support, which they want to add an additional $144, which I cannot afford. Besides that, I don't really know what else to say.
Anything else from the Attorney General's office?
No, Your Honor.
All right. All right, Mr. Kuyati, based on what you informed me today, and in addition to taking judicial notice of the court's file, all the documents that have been filed and pled, which I did review prior to today's proceeding, I'm denying your request for de novo. Or I'm denying your relief request for de novo is probably what I'm making a ruling on. So the order that was issued on April 16th still stands. So if y'all want to give me just a real simple order that just says a relief requested in the hearing held on May 8th is denied.
We can definitely do it, Your Honor. I know we have another hearing in another court, and then I want to meet in for my office. It's going to be later today. Thank you, Your Honor.
All right, thank y'all. We'll be in recess. Thank you.
Can we talk for a minute? Because I have some questions about some of the things you said, if that's okay.
Can I fill my stuff over first?
Maybe outside afterwards?
Electronically in my email.